citizenry in the matter of Drelle and Servis-Terminal LLC in liquidation in the Russian Federation.
Mr. Selleck. Good morning, my lords. May it please your lordship, I appear for the appellant in this matter with my learned friend Mr. Bickford Smith and my learned friend Mr. Phillips KC and Ms. Johnson appear for the respondent. My lords, I've spoken with my learned friend and I hope will finish my first round of submissions before close of play today. My learned friend will then have his go tomorrow and I'll wrap up briefly tomorrow. My lords, there are 4 grounds of appeal, so I'll crack on with the first ground immediately. And the argument proceeds, lords, in the following way. Under section 2672B, which if your lordships will be familiar with it, but it's Authorities Bundle 3, page 14, a creditor's petition may be presented to the court in respect of a debt or debts only if at the time of the petition is presented the debt or each of the debts is for a liquidated sum payable to the petitioning creditor or one or more of the petitioning creditors either immediately or at some certain future time and is unsecured. My lords, whether there is a debt or whether the debt is payable immediately or at some certain future time is an issue that's to be determined obviously under English law. And if, as a matter of English law, there is no debt, or it's one which isn't payable immediately or at some certain future time, then there's no petitionable debt under section 267. And my lords, as we submit in paragraph 10 of our skeleton argument, the common law rule, your lordships can turn it up if they wish at Authorities Bundle, tab 42, page 792. The common law rule is expressed in...
Should we be reading that? Or?
Yes, my lord. Yep. So, tab 42, page 794. And the common law rule is clear that a foreign judgment has no direct operation in England, say that there are 2 exceptions or possibilities. One is that it may be enforceable by claim or counterclaim at common law, so an action on the judgment, or under statute, such as the 1920 or 1933 Act, or it may be recognised in one of 2 ways, as a defence to a claim or as conclusive an issue in a claim. And Dicey helpfully at 794 and 795 at 14003 explain that there are 3 categories in which the question of recognition and enforcement may arise. And the first category is where the person who's got the benefit of the foreign judgment may seek to have the judgment executed or otherwise carried out as against the person against whom it's given. And then your lordships see at 795 at 14-005 that there's the first of the recognition categories, and that's to say a foreign judgment may sought to be relied on to resist a claim in the same or connected matter. And again, as is clear in the middle of that paragraph, there's no question of enforcement, it's a matter of recognition. And then at 14006, the party against whom judgment was given may seek to use that judgment or the fact that it satisfied the judgment to resist a further claim by the party in whose favour the judgment was given. And again, that's a question of recognition. And, my lords, the proposition that a foreign judgment has no direct operation in England has been expressed in several ways, and I'm going to show those now to my lords. First of all, in the same Authorities Bundle, please, at tab 39, this is from Professor Briggs's 4th edition. We have the 5th edition as well, but I want to show you lordships the 4th edition first. At page 782, the professor states at the top of the page, the first and most important thing to understand about foreign judgments is that judgments of foreign courts have no direct effect in England. For foreign judges, and these are the key words, for foreign judges have no authority in England. And then, my lords, we'll come back to this article, but for present purposes, if your lordships then go to tab 40, please, at 785, this is now the 5th edition came out relatively recently. Professor Briggs puts it slightly differently at the top of the page. The first rule of foreign judgments is that judgments of foreign courts have as such no legal effect in England, for foreign judges have no authority in England. And then Your Lordship sees the next sentence, we'll come back to that. Then about 6 lines down, as judicial adjudication is an exercise of state sovereignty, this is obvious. State sovereignty ends at the border of the state, and while international comity may certainly require that respect be given to exercises of that power within the sovereign's own territory, that's where the conventional obligations of comity end. And then, my lords, at tab 38, please, in the bundle.
Just before you go on, so
Yeah.
you were showing us a moment ago. No, I see. Yes, okay.
Tab 38 of the bundle is an article of Professor Briggs in the Law Quarterly Review from 2012, and 767, I should say. And at 768, he explains in the middle of the page, the paragraph beginning now, that foreign adjudication and judgment are to be understood as being acts of state sovereignty. And the common law draws two conclusions from that. Second line, it is regarded, that's the foreign judgment, as completely effective within the territory.
I'm so sorry, I haven't...
Sorry, my lord, it's my fault.
Found you.
My fault. So it's the middle of the page, paragraph, my lord, beginning now, if a foreign adjudication, page 768.
I've got you now, thank you.
It's my fault, my lord. Now, if a foreign adjudication and judgment is understood as being an act of state sovereignty, the common law draws two conclusions. It's regarded as completely effective within the territory of the sovereign and as completely unenforceable outside it. The fundamental rule of the English common law has always been that an English court has no jurisdiction to enforce a foreign penal, revenue, or what's sometimes described as another public law. There is now general agreement that Dicey's Rule 33, which is what that is, your lordships know, is a particular manifestation of a more fundamental rule that an assertion or exercise of the sovereign right of a foreign state will not be enforced by an English court. It follows that in the absence of legislation, a foreign judgment cannot be enforced in England. And Lord, there is no doubt that these views are correct, because this court effectively so held in Owens and Bracker. If your lordships go in the authorities bundle, please, at tab 11, and that was Owens and Bracker was a case where there was an action under the 1920 Act to register a St. Vincent judgments, and there was resistance of that by the defendants. And they applied for an order that the English court declined jurisdiction under the lis pendens provisions of the Brussels Convention, and there were appeals to this court on the issue of whether the convention applied the judgment of a third-party state. And that issue, as your lordships will recall, went to the ECJ, who held that the Brussels Convention did not apply to third-party state judgments. And the matter then comes back to the House of Lords, where it's made clear that in relation to fraud, where fraud is relied upon to set aside the judgment, under section 9(2)d of the 1920 Act, one doesn't need to have fresh evidence because the common law rule in Appellant and Oppenheimer still applied, and that governed the interpretation, we'll come back to that, governed the interpretation of section 9 of the Act. But, my lords, for present purposes, at page 132, in the judgment of Lord Justice Parker in this court, his lordship said, actually maybe if your lordships start at the bottom of page 131, please, right at the foot of the page, before stating the submissions made by Mr. Mann for the bank, which have raised questions of fundamental importance in the law of enforcement of foreign judgments, which aren't covered by the 1968 Convention, it's necessary to state briefly the course of the development of the common law on this subject. The first method of enforcement here of a foreign judgment was by an action upon the judgment. the foreign judgment, in the absence of statute, could have no direct operation in England and Wales because of the principle of the territoriality of a court's jurisdiction. And, my lords, then, if your lordships can go, please, in the bundle at tab 42, please. That's actually we can. Sorry, Mills. I've shown your lordships that already. We don't need to go back to that. Lords, the reference.
You showed us the Court of Appeal in Owens. Were you going to show us something in the House of Lords?
Not yet, no, because it's not. There was later, but not on this particular point. But there was nothing said in the House of Lords which in any way cast any doubt on what Lord Justice Parker said in the Court of Appeal. Okay. My lords, the reference to direct in the expressions direct effect and direct operation emphasise the principle that the foreign judgment itself has no legal effect beyond the two further possibilities posited in Dicey Rule 45. So, if it is desired to use the foreign judgment as a sword and not simply rely on it defensively or just for recognition purposes or even for on the basis of an issue estoppel, if one wants to use it as a sword, that's to say enforce it in the broad sense of that word, not in any legal term of art or technical word away, then as Professor Briggs has stated, and as this court has stated in Owens, the foreign claimant has got to bring an action on the judgment at common law. If your lordships please could go back into the authorities bundle, again, at tab 38, back to the Law Quarterly Review article, please, at page 768, please, tab 38, 768, 4 lines up from the bottom of the page, Professor Briggs says this: the theory about the unenforceability of the foreign judgment and the fact that the territoriality of the foreign state ends at its borders is illustrated by the practice. A successful litigant with a foreign judgment in his favour cannot enforce that judgment in England. No measures of execution may be taken on the strength of it. The claimant must instead bring original proceedings before the English court in order to obtain speedily or eventually an original English judgment, which alone is the judgment which can be enforced. The nature of these English proceedings will depend on the nature of the anterior foreign judgment. If the foreign judgment took the form of a final order to pay a sum of money, the claimant may sue to recover that sum as a debt due and owing. The issue of a claim form, followed by an application for summary judgment, will in many cases produce an enforceable English judgment in short order. Then, my lords, the Professor then deals with a non-money judgment. If you then look at the middle of the page, please, in the next paragraph, as Dicey said in his first edition, a foreign judgment has no direct operation in England, and nothing material has changed. Whereas some civilian systems required a claimant to sue all over again using the foreign judgment as nothing more than evidence of the soundness of the claim, and others required the claimant to obtain a decree of exequatur, which gave leave to enforce the foreign judgment. The common law may have appeared to be different, but it produced very similar effects by requiring the successful party to obtain an English judgment which he might then proceed to enforce. In this respect, the common law and civilian systems are of one mind. Foreign judgments may not be enforced. The role of a foreign judgment is to prepare the ground for the making of a local order. And, my lords, then in tab 39, please.
So why did you skip over the bit at the end of the first paragraph about non-monetary judgments?
Because we're not, first of all, we're not concerned with a non-monetary judgment. But your lordship's right in this in the sense that I should show your lordships the last sentence of that paragraph, because what Professor Briggs is saying is either course results in a judgment of the English court, and it's this which is enforceable in England. So in the bit I skipped over, I didn't mention it because it's if the foreign judgment is otherwise. In other words, it isn't for a sum of money. That was why, because the foreign judgment in this case is for a sum of money. But the principal point is that last sentence. Either course results in a judgment of the English court, and it's this which is enforceable in England.
Yeah. So so the distinction in a sense is it doesn't matter. I mean, the point, your general point is whatever the judgment abroad, you've got to get it registered.
Precisely so.
Yeah.
Precisely so. And then, my lords, please, at tab 39, which is at, again, this is the 4th edition of Professor Briggs's book, at 782, please.
I think the numbers are
Oh dear.
lost.
So,
well, we can look at the
so
internal
top of the page is 127, top right.
Yes.
So the internal pagination. Yeah, I wrote these down manuscript. I was hoping that my lords had white pagination. Obviously not. Right. So I will give the internal pagination. I'm sorry.
And just to understand, why are we looking at the 4th edition, not the 5th?
Well, we are looking at the 5th as well, only because the 4th was the one which was looked at by the judge, and I just thought it appropriate and correct that your lordship should see that,
Yes,
in
I see.
fairness to the judge, and also then show my lords the updated edition.
Yes.
That's all. I mean, it's there's no change in view as expressed by the professor. So, my lords, internal page 127, in the paragraph beginning, accordingly, foreign judgments may have effect in England, according to the common law. He then talks about the registration scheme, about 5 lines down, but where there is no registration scheme and the common law is relied on, though the foreign judgment may be recognised as res judicata, it can't be enforced as a judgment. Instead, the judgment creditor uses the foreign judgment to obtain an original, albeit derivative, English judgment, and it will be this English judgment that may then be enforced and executed on. The English court does not rubber stamp or authorise enforcement of the foreign judgment. It doesn't grant ex equatur leave to enforce the foreign judgment in the manner in which the civilian tradition has it. It gives a judgment of its own. And then, my lord, if one looks at the next page, please, that's 128 internal. At the top of the page, Professor Briggs deals with statutory registration. But then, and then he deals in the next paragraph with the European regulations, which are also now gone. But the last paragraph on that page, please, it bears repetition. Where the foreign judgment is not subject to a statutory registration or post-registration scheme, the common law alone supplies both the rules for recognition and enforcement, as well as the procedure for enforcement. For these cases, the foreign judgment may be recognised, but if anything is to be enforced, it will be an English judgment derived by one means or another from the foreign judgment. It's sometimes said that at common law, one enforces a foreign judgment by bringing an action on it. The common law may be represented this way, but as it is written, the proposition is liable to mislead. The foreign judgment provides the cause of action for proceedings to obtain an English judgment, which is what the judgment creditor may then enforce. And then, my lords, in his 5th edition, at tab 40, internal pagination 117, top of the page, so it's basically it's the first sheet over the page. So internal top right 117. The last paragraph, the issues raised by a foreign judgment in favour of the claimant are more complex. If the claimant obtained judgment in respect of the whole of the claim, she may wish to go beyond recognition to bring proceedings which have the effect of enforcing the judgment, say by demanding payment of the sum which the foreign court ordered to be paid and which remains unpaid. If it is to be enforced at the behest of the successful party, the foreign judgment must first be recognised, then satisfy further conditions. If this is successfully done, the English court will give its own judgment in the claimant's favour, which she may enforce as an English judgment because it is an English judgment. And then, please, my lords, internal next page 119, Professor Briggs looks at the statutory screens, bottom of the page, where a foreign judgment does not benefit from any of these statutory schemes, it's left to the common law to supply both the rules for recognition and enforcement, as well as the procedure for enforcement. The common law pays no attention to the presence or absence of reciprocal treatment. English courts will recognise and enforce judgments from courts in countries which have never enforced an English judgment and probably never will. This makes perfect sense, for the common law is not concerned with interstate relations or cooperation between courts, which is a matter for governments, but focuses on the relationship between the litigants with regard to proceedings before the foreign court. Recognition of the foreign judgment doesn't require legal proceedings, though legal proceedings may confirm this effect. But if anything ordered by the foreign judge is to be enforced in England, the judgment creditor will, as was said above, need to obtain an English judgment derived by one means or another from the foreign judgment. This leads some to say that one enforces a foreign judgment of common law by bringing an action on it, but what this really means is that one enforces a foreign judgment of common law by using it to bring an action to obtain an English judgment, and one enforces that. The truth is that a foreign judgment furnishes a cause of action for proceedings to obtain an English judgment, and it's the latter, not the former, which the judgment creditor may then enforce, and then goes on to the common law. And then lastly, my lords, in the professor's work, The Private International Law of the English Courts, which is in tab 41, and another problem with the pagination. But if your lordships look over the page of the first page, it's internal 321. It's really, I don't need to read it out, it's really to the same effect. Bottom of the paragraph, but if the party in whose favour the judgment was given wishes to go further and have the losing party order do the thing which the foreign court ordered him to do, but which he hasn't yet done, that is to use the foreign judgment as a sword, she will need an English judgment to that effect, and so on and so forth. So it's the same point. And then, my lords, I said lastly, that was a ill-considered expression, now lastly, Dicey at tab 42, please. At 798, now back to normal pagination, please. At 14-011 on page 798, under the heading Enforcement of Common Law, the editors say the statutes which deal with the enforcement of foreign judgments have limited geographical application. The judgments of very many foreign countries, including important trading partners for the UK, such as the United States, aren't within their scope because there's no treaty arrangements in place with these states for the reciprocal recognition and enforcement of judgments. There thus remains a considerable area within which enforcement at common law is the only process possible. So, my lords, the common law rule is not only limited to the foreign judgment not being able to be enforced by the method of execution. The common law is much broader. The common law doesn't state, or isn't stated and understood in terms limited to execution. And indeed, if that were the case, it wouldn't give effect to the rationale for the rule, which is that the sovereignty of the foreign judge ends at the borders of the relevant foreign state. Secondly, my lords, the rule is that the foreign judgment has no legal effect, no direct operation, no direct effect, as I've shown, my lords, in the passages a few moments ago. Thirdly, my lords, the effect of the judgment not being able to be enforced, in the broad sense, is that it entails that a person who disobeys a foreign judgment isn't in contempt of court, and that's, I'll just give you lordships a reference, that's in Briggs's 5th edition at tab 40, authorities, page 785, and on the same page 4-3, it entails that no one is in peril in England by reason of a foreign judgment if it isn't satisfied. So references to enforcement got to be understood, we submit in this wider sense. And the fact that dicey may give a specific reference to enforcement by execution really proves the point. Because to use the phrase enforcement by execution is explaining or setting out a particular method of enforcement, but it is not the be-all and end-all of the common law rule. So
Sorry.
no, my lord.
So Professor Briggs, I think, doesn't talk about enforcement by execution.
Correct.
He talks about enforcement more generally.
Correct.
Somewhere along the line, you had a second proposition, which was something along the lines of that somebody is not put in peril.
Yes,
Are you quoting from somewhere?
I am. I had said this on the same page, but I'll show my lord the passage. So it's at Authorities tab 40, please. This is from the 5th edition of Professor Briggs's work. At page, so it's the first page. And your lordship sees, 4th line, no persons in contempt of court or otherwise in peril.
Right, but that's okay.
No.
That's a bit of that wording is a little bit of a flourish by Professor Briggs. I mean, it's not a term of art.
Well, it may not be a term of art, but if one faces a bankruptcy petition, you're in peril. And in peril means, we submit, that you're not at risk of having something prejudicial, if you will, happen to you. There are many ways one could be in peril. So, my lords, there is a distinction, we say, on the one hand, enforcement in the sense of treating something as having legal effect and actively seeking a benefit from it, which is what you can't do with a foreign judgment unless you've got a judgment in an action of common law, it's registered. And on the other hand, a particular or specific method of carrying out that enforcement. I'll be showing your lordships a decision of this court which makes that point clear. And it's also material, as again I'll mention in my submissions later, because it confronts head-on the respondent's misconceived argument that the common law rule is limited to enforcement by execution. Lords, whatever views one may have about the propriety or correctness of the common law rule or its relevance, to use that buzzword, in the modern world, the fact is, to use another horrible expression, it is what it is. And Professor Briggs makes the point that we respectfully submit rather nicely in the authorities bundle of tab 38, please, page 780, again back to his Law Quarterly Review, and actually it's right at the last page, page 780. And he says, well, I may invite my lords to read that to yourself.
Sorry, which bit?
If that's okay. Under conclusion 5, and then
So that paragraph.
Yeah, and could I ask you, lordships, also to read postscript 6, if that's
Yes,
okay.
we'll do that.
So, Lords, can I now turn to...
Just
Yeah.
you asked us to read the postscript, which is Reuben and Europhone.
Yes.
I mean, that is not in the bundle, is it?
It is not. We can produce it for your lordships if you want. It was referred to below in a slightly different context, the context of Lord Millis explaining the theoretical basis for an action on the foreign judgment. But I mean, obviously it's a different case. It's of some relevance. because it does show that judgments, that insolvency judgments, which may fall within the model law but which therefore can't be enforced as a judgment, nevertheless are still subject to the common law rule. And of course, Mr. Rubin succeeded, but in the other case there was no success because the Supreme Court held that they had submitted to the jurisdiction. And therefore the foreign judgment was enforceable at common law.
I mean, I wonder whether,
Yeah.
at least because you've taken this to this postscript, it would be worth supplying a copy of that.
We'll get that for your lordship for 2 o'clock if that's okay.
Yeah, thank you very much.
So, my lords, let me now turn to the question of the nature of bankruptcy or insolvency proceedings. Now, whilst it isn't, or they aren't a process of execution, which we've always accepted, they are a legal proceeding for collective enforcement. Don't need to tell your lordships that, your lordships well know that. And judges and textbooks speak of petitioning for bankruptcy or insolvency in a broad sense as enforcement, not as a specific method of enforcement like execution, but enforcement. And I just want to show, my lords, some authorities in that regard. First of all, back to the authorities bundle, please, at tab 10. Re Lines Brothers, I think is a case referred to by my friends. That was the case originally concerned the date when foreign currency debts should be converted into sterling, and it was at the start of the winding up, which was, of course, in accordance with the general rule for the valuation of liabilities based on the Miliangos case. But in the course of the judgment pleas at page 104, first of all, Lord Justice Lawton, top of the page, 4 lines down. At the end of Mr. Stubbs' opening, I thought his submission was right. Mr. Graham and Mr. Potter have persuaded me it ignores the juridical nature of liquidation is fallacious. As I've already said, liquidation is a form of collective enforcement of liabilities under English law. Liabilities are what the court will enforce. That's trite, but it's mentioned. Word still there in enforcement. But then more pertinently, what Lord Justice Brightman says, please, my lords, at page 110. So, having referred at letter B and C to the Miliangos case, at letter D, 2 lines below letter D, his lordship says this in an important passage: if the creditor petitions to wind up a company or claims in a liquidation initiated by others, he is not engaged in proceedings to establish the company's liability or the quantum of the liability, although liability and quantum may be put in issue, but to enforce the liability. Indeed, he is precluded from initiating or supporting a winding up petition if his status as creditor is bona fide disputed by the company. The liquidation of an insolvent company is a process of collective enforcement of debts for the benefit of the general body of creditors. Although it's not a process of execution, because it isn't for the benefit of a particular creditor, it is nevertheless akin to execution, because its purpose is to enforce, on a pari passu basis, the payment of the admitted or proved debt of the company. And then, my lords, please, at tab 19.
Just pausing briefly. The foreign judgment debt would be provable. So at the stage of collective enforcement contemplated by Lord Justice Brightman, you do take into account the foreign judgment debt.
Because section 382 of the Act allows you to do so, yes. But my lords, it's the passage beginning 2 lines below D. If the creditor petitions to wind up a company, so this is before the liquidation kicked in, Lord Justice Brightman says when he petitions, he's not engaged in proceedings to establish the company's liability, but he is engaged in proceedings to enforce the liability. So they are proceedings or for the purpose of, to is used in that sense, for the purpose of enforcing the liability. Obviously, when the company goes into liquidation, then that's when the process, obviously, of liquidation starts. But it's the prior stage which is an enforcement proceeding. My Lords, then at...
But sorry, just to come back to my Lord's point, and forgive my ignorance, there's a specific provision in the Insolvency Act that says once you get to proof of debts, a foreign judgment is provable.
No, Lord, no. There is a specific provision in the Insolvency Act, Section 382, which defines what a bankruptcy debt is. Doesn't mention foreign judgments, just defines what a bankruptcy debt is. It allows a bankruptcy debt, that's to say a debt which is provable, to be a contingent debt. It's much wider, but Section 267, which refers to when a creditor may petition, doesn't define debt. And of course, the definition of Section 382 doesn't apply to that debt in 267, because the definition in 382 is looking to a time after the bankruptcy order has been made. And that's a distinction which is also made by the Court of Appeal in a case called Duodu. So there's no dispute between my learned friends and us on that particular point. There is no statutory definition which is material here. The only definition of a bankruptcy which is in play, a la the Lord Justice Dewey's question and your Lordships, is bankruptcy debt. That is defined, yes, but that relates to bankruptcy debts. That's to say, debts for the purpose of proving in the bankruptcy once a bankruptcy order has been made.
But an unrecognised foreign judgment debt is a provable debt, is it, or not?
A sum, can I respectfully rephrase that? A sum awarded under an unrecognised foreign judgment may be provable, yes. My Lords, then at tab 19...
And how does that sit with your general proposition at Dicey Rule 45?
Because...
That it can't have any direct effect here.
Well, one still may be able to prove, because there's specific statutory provision which defines what may count as a provable debt. And
is one explanation of that the process of collective enforcement, which a bankruptcy or a winding up is said to be, is one whereby your individual rights to enforce are suspended in favour of the operation of a statutory scheme. Lord Hoffman said that in the Privy Council in a case that I just can't remember the name
Cambridge Gas.
No.
Was it? No.
I'll remember it. So your rights of enforcement are suspended in favour of the operation of a statutory scheme under which you have rights. The rights are to receive a distribution, and it's the liquidator or the trustee in bankruptcy that goes after the assets, to use a not very technical term, and to collect them in for the benefit of everybody. And it's perfectly possible to envisage a situation in which the rights to participate in the statutory scheme are given to a broader category of people than would be capable of enforcement.
Yes.
And indeed a broader category of people than might be able to invoke the collective process.
Well, your Lordship has put it, I may respectfully say so, most eloquently.
I'm not saying it's right, I'm just saying that's a possible explanation of the disconnect between those who can initiate the process and those who can benefit from it, because you're talking about, as you say, two different stages of a statutory process.
That is how we would respectfully put it, my Lord. And we would respectfully say that is right. That is a right explanation. My Lords, then at tab 19, don't, I think, need to refer, well, there's Ridgeway Motors, I think referred to by my friends. Again, It's at page 319. I don't need to take your lordships here, just for your lordships note. We don't disagree with anything there. Shulson and Keane, which is at tab 17. And that was an appeal by the well-known...
Tab 17.
Tab 17, Lord.
Yeah.
That was an appeal by the well-known Mr. Shulson against a registrar's refusal to set aside statutory demands in respect of unpaid building work. And one of the grounds of the appeal was that the JCT contract between him and the builders contained an arbitration clause, and section 9(4) of the Arbitration Act required a stay of the statutory demand, assuming an application was made, and the appeal was dismissed, and as regards that particular issue, on the basis that a statutory demand didn't constitute the taking of legal proceedings within the meaning of the section. But at page 284, Mr. Justice Blackburn, at paragraph 20, says, it seems to me that Mr. Shulson has had it both ways. He denies to Keane the option of enforcing its claims through the bankruptcy court by pointing to his right to have recourse to the arbitration process. Yet he claims the right to sit back and do nothing to invoke the process. And then at 23, in the middle of that paragraph, I see nothing improper in a creditor resorting to bankruptcy proceedings as a means of enforcing payment. The mere fact that other methods of dispute resolution are available doesn't disentitle the creditor from proceeding down the bankruptcy path. And then, my lords, HMRC and Morris, which is at tab 20, that was a case where HMRC presented a petition against Mr. Morris for about £50,000 following a Belgian judgment in favour of Belgian customs because of the importation of cigarettes, and the Belgian authorities requested the assistance of HMRC to collect the money due. And one of the points we can see at page 32, again, it's the same problem, so it's top right, internal pagination 393. One of the points taken by Mr. Morris at 2 Roman 3 was that bankruptcy wasn't a method of enforcement available to enforce a claim made pursuant to the relevant council directive. And the issue under the regulations, Your Lordship sees over the page at internal 396, and there are regulations which allowed mutual reciprocal recovery, and the relevant bit is at the bottom of 10. Proceedings may be taken by or on behalf of the relevant UK authority to enforce the foreign claim by way of legal proceedings, distress diligence or otherwise, as might be taken to enforce a corresponding UK claim. And his lordship held that the correspondence condition was satisfied, and then at 32, which is a page internal 404, his lordship said no reason for distinguishing between bankruptcy petitions on the one hand and winding up petitions on the other.
Sorry, I've lost.
I'm so sorry. So it's the last page of the report, my lord.
Sorry, which of the bundle number?
Oh, I'm sorry. Well, you can't see the bundle number.
No, but I can.
Internal 404, top left, tab 20.
Yeah, but sorry, what's the bundle? Oh, sorry. Okay, you don't know the bundle number.
The bundle number is tab 20. Oh, authorities bundle. Oh, I see. I don't.
I've got it electronically.
Oh, I'm sorry. I've got it hard copy.
Okay.
Sorry.
No, okay. Don't worry. I'll find it. I've got it.
337. I'm told.
That's good. Thank you.
337.
Yeah. Sorry.
Sorry.
Got it.
32. No reason for distinguishing between bankruptcy petitions on the one hand and winding up petitions on the other, or for the orders made pursuant to each, nor is there any distinction of any substance to be drawn between collective enforcement and individual enforcement. As part of the judgment which I've referred above makes perfectly clear, insolvency proceedings, they're winding up, but in my judgment, equally individual bankruptcy petitions are legal proceedings and illegal proceedings for the collective enforcement of admitted or proved debts. So,
and just out of interest, sorry, you were right. I think it was Cambridge Gas. Sorry, Navigator, Cambridge Gas Navigator in the Privy Council. Yeah, sorry, you're right.
Which, although of course it was disapproved in ruling, that passage is still obviously correct. My lords, the judge in paragraph 34 of the judgment, which is at core bundle A90. That's core bundle A90. The judge at 34 said, and I quote, that he was far from convinced that the process of picking through isolated phrases used by judges deciding different issues sheds much light on whether the presentation of a bankruptcy petition constitutes enforcement for the purpose of Rule 45. And Lord, we were not picking through isolated phrases, but what we were doing was trying to show the judge that bankruptcy proceedings were proceedings to enforce in a broad sense. And, my lords, again, as I've said, as a matter of legal analysis, given that the underlying principle in relation to the standing in English law of a foreign judgment is one of sovereignty and territoriality, it's difficult to see, again, picking up my learned friend's objection in relation to execution, why a foreign judgment's effect in this jurisdiction should be different depending on whether enforcement is by a particular method as opposed to just enforcement generally. If, as in Re Lyons Brothers and in the passage from Lord Justice Brighton, which I cited before your lordships, petitioning for bankruptcy are proceedings to enforce a liability. And the liquidation there was a process described as being akin to execution. Then there's no justification in logic and legal logic anyway to distinguish it from direct execution. But the principal point is it is enforcement in the broad sense. Now, my lords, this distinction between enforcement in the broad sense, which is what the Dicey rule prohibits, and a method of enforcement is borne out by this court's decision in the International Tin Council case, which your lordships find in the supplemental bundle of authorities at tab 3, page 16. And it's a case which we thought it important you should see, and that's why it's there. That was a case where the petitioner obtained an arbitration award of over £5 million against the International Tin Council, the ITC. The ITC was an international organisation established by treaty and constituted under an international agreement. The petition was on the basis that the ITC was an unregistered company within the meaning of Section 665 of the Companies Act 1985. The ITC applied to strike out the petition on the basis that it was an international organisation, and therefore the court had no jurisdiction under domestic law. And moreover, that the ITC had immunity from suit under Article 6 of the ITC Immunities and Privilege Order of 1972. The judge, Mr. Justice Millett, as he then was, held that the ITC wasn't subject to the winding up jurisdiction of the English court. It wasn't within the definition of an unregistered company, despite the wide words of the section. So the issue of jurisdiction was decided in its favour, but he went on to hold that it was immune from suit under the terms of Article 6.1, and this court dismissed the appeal. And if your lordships please turn to page 38, which is part of the judgment of Lord Justice Norse, we can see at letter C what the terms of the relevant provision in the order Article 6 was. The ITC shall have immunity from suit and legal process, except in respect of the enforcement of an arbitration award. Now, the judge held that the expression suit and legal process included winding up proceedings, and that point wasn't pursued on appeal. And so, as Lord Justice Norse observed at letter D, the sole question was whether the presentation of the petition based on an arbitration award was a proceeding in respect of an enforcement of an arbitration award. The Court of Appeal held it wasn't, but their reasoning is important. And the court referred to earlier cases which had to address that particular expression, whether bankruptcy proceedings were a method of enforcement. So, my lords, at page 38E, reference is made to the case rear bankruptcy notice, and Lord Justice Fletcher Moulton's judgment that an application for a bankruptcy notice wasn't enforcement within the meaning of Section 12 of the then 1889 Arbitration Act. And if your lordships look at letter H at 38, at the bottom of the page, in my judgment, an application for a bankruptcy notice is not a method of enforcing a judgment. It's the commencement of proceedings of a far wider effect, not intended to be included in the words of Section 12. And then at letter B, issue a bankruptcy notice is the same general effect as the presentation of winding up petition. Your lordship sees the rest there. And then, my lords, reference was made at letter C to in re a company. And the question in that case was whether a bankruptcy petition could be presented without application, first being made under Section 1 of the Courts of Emergency Powers Act 1914, because obviously it was a time of war. And that provided, as what you lordships see at letter D, no person shall proceed to execution on or otherwise to the enforcement of any judgment. And then, my lords, at letter E, Lord Justice North said that this court answered that question in the affirmative on the ground that a winding up petition was neither proceeding to execution nor a proceeding to the enforcement of a judgment within the meaning of the subsection. And the words of Lord Cousins Hardy, Master Rolls, were then quoted, and lordships see what he said there about equitable execution being not execution itself, but analogous to legal execution. And the words otherwise to the enforcement of the judgment precisely meet the case. And then, my lords, over the page, please, at letter, forgive me, at the bottom of the page, Lord Justice Laws quoted, or referred to Lord Justice Phillimore, 5 lines up to the foot of the page. The words execution and enforcement of a judgment were terms of art. After referring to equitable execution as a means of enforcing judgments to which the latter words could apply, he said at 528 that in some general loose sense, an unsatisfied creditor might be said to be enforcing his judgment by presenting a petition for winding up. Later, he said of the petitioner in that case, in the particular case, she's a creditor because her damages have been liquidated by a judgment. But it would be the same if she were a simple contract creditor whose debt was merged in a judgment. She is not therefore seeking to enforce her judgment. She is proceeding to a new alternative mode of recovering her debt, a mode by which she no longer seeks to recover for herself alone, but for the benefit of all the creditors, and so on. Those words are important. I'll come back to those because they show that one of my learned friend's submissions about the meaning of Section 6 of the 1933 Act is in error, but I will come back to that. And then, my lords, at letter G, Lord Justice Norse referred to a submission of Mr. Morritt, as he then was, and at G, the argument was described as one of rare subtlety, but which failed at the outset, on the ground that the petitioner, having obtained the arbitration award before presentation of the petition, is thereafter seeking to enforce the award and nothing else. And then over the page, my lords, at letter C, we're in no doubt that all the observations relied on by Mr. Morritt were used in the general loose sense referred to by Lord Justice Phillimore, that's the enforcement in the loose sense. They are of no assistance in construing an expression which has effectively been held to be a term of art, more especially one which has been held to be such long before the formulation of Article 6 of the 1972 order. So, my lords, we submit that case as authority for a number of propositions. First, that expressions in statutes and statutory instruments, such as execution and enforcement of a judgment, are terms of art. Those terms do not include petitioning for bankruptcy or winding up. Of course, this case is not concerned with any such term of art. Secondly, the pursuit of bankruptcy or winding up proceedings is a legal process, and the respondent, we understand, doesn't quarrel with that. Thirdly, that in a general sense,
pursuit of insolvency proceedings is
a legal process.
Yeah.
Sorry, my lord, I was going too quickly. Thirdly, that in a general sense, an unsatisfied creditor is, by presenting a petition for bankruptcy or winding up, seeking to enforce his judgment, and of course that's consistent with the other cases that I've shown, my lords. And fourthly, that by presenting a petition, the petitioner is seeking to recover their debt, not for themselves alone, but for the benefit of all creditors. But it is still a mode of recovery.
Well, I'm not... Okay. I can understand, incidentally, I was partially right, as well as Cambridge Gas. There's also, it's White and Eckhart Marine, I was thinking, which preceded Cambridge Gas, where the same point was made. Okay, it all goes back to Lyons Brothers, though.
Yeah.
I'm not sure I necessarily follow the point about recovery. I well understand why you say if you're petitioning for either winding up or a bankruptcy order, that you are seeking to enforce your debt, albeit in a collective process, in a collective way. In fact, what you're seeking to do is to institute a process whereby somebody else engages in a process of collective enforcement. But I don't think you, quote, recover your debt. What you do is you agree to be paid a distribution of whatever assets are collected in that process, and you receive a pari passu distribution which pro tanto discharges your debt. But so it's only recovery in a sort of pretty indirect way through a statutory process. It's not what you would normally call recovery in the individual sense. I mean, you do receive a payment from the statutory process, which will be treated as discharging your debt, but your debt as such is not affected in any way by the process. That's what White, Eckhart Marine and Cambridge Gas say.
I don't quarrel at all.
So why are we talking about recovery?
Well, principally because I'm going to rely on that passage in relation to a submission advanced by my learned friends, in relation to the interpretation of Section 6 of the 1933 Act. I'll come to that. But I wanted to mention it now, so I wasn't hopping back and forth between the cases. But your Lordships have our general submission, and as I say, I don't quarrel with what your Lordship has said. Lord, can I now turn to the issue of the 1933 Act?
Just before you do, while it's in my mind, this is going off to tangent. We're concerned with bankruptcy, and before 1986, you needed a judgment to get a bankruptcy order, but you didn't need a judgment to get a winding up order. So one might think that all these questions could have arisen well before 1986 in the corporate insolvency context. Now, we're not referred, I think, to any authority from the corporate insolvency context.
No, because we don't think there is one. Yeah. The only case, and I don't use the word authority because it doesn't bind this court, but there has been a case subsequent to the judge's decision in this case, which was a decision of the insolvency judge, which relied on Mr. Justice Richard's judgment to, I think I'm right, in, get your Lordship's copies, reference, but which I think dismissed an application to set aside a demand, or it may have allowed, which is odd, corporate, I know, it may have allowed the petition, I'll check that, but it's a decision which is applied by the ICC judge, relying on Mr. Justice Richard. We haven't produced it before, your Lordships, because it doesn't...
it just follows this one.
It just follows this one, and
I suppose my
yeah.
puzzle is, look, one can understand that there were special considerations in relation to bankruptcy before 1986, but they didn't apply in relation to winding up. You say, well, they didn't apply in relation to winding up because no one thought that you could present a petition based on a foreign judgment.
That's right, and people didn't. And we can have a look later at maybe I can show you Lordships very quickly now, slightly out of order. I will. Your Lordships have the supplemental bundle, please. If your Lordships go right at the very bad. So I'll give your lordship the page. It is, yes, so it's page D97. Because, as your lordship will have gathered, this point was not one which was taken before the ICC judge. Of course, Mr. Justice Fancourt gave us permission to raise it in the grounds of appeal, so that's why it was live before Mr. Justice Richards. But at D97, having made various submissions, my learned friend, Mr. Phillips, D97, internal 89, line 7, said, can I just pick up, whilst I'm here, one of the points my learned friend just made. He's always concerned with cases in bankruptcy based
Sorry,
on...
I've lost
I'm
it.
so sorry, my lord. Internal page 89, top left.
That's where I'm getting wrong.
So it's D97 is the middle bottom page. It's the transcript.
Yes.
And internal top left, page 89.
Yes.
Can I just pick up while I'm here one of the points my learned friend, that was Mr. Davenport, just made. He's always concerned with cases in bankruptcy based on Russian foreign judgments. There are many cases in bankruptcy based on foreign judgments. We've all done it. We've all come across it. The fact that there's a foreign judgment means the test, the question you ask as to whether or not that foreign judgment is in breach, is the test I've just articulated. Now, the judge said, I haven't been taken to any such judgments, but all those that immediately spring into mind, in my experience, are those that involve recognition of the judgment. My friend said, but not necessarily. The judge, and are there examples where an unrecognised judgment has been the subject of a bankruptcy? Yes, absolutely. I mean, certainly in my experience, Judge, I'm trying to think of any, and then the point is not completed. But then afterwards, at D98, please, at top right-hand corner, page 99, just before the short adjournment, line 5, the judge says, we've some time this afternoon, my main concern is we weren't getting to this point and realising we don't have enough. In other words, that was the point on foreign judgments. And then after the short adjournment, my learned friend, Lordship C, that page 100, line 10, produced Muir-Hunter, which stated at 19, in principle, a demand or petition based on a foreign judgment will be recognised for bankruptcy purposes without the need for specific registration in the UK. But there was no authority cited for that proposition at all. And then reference was made over the page, I think maybe reference was made, but anyway, Sun Legend, which was the case where the debtor admitted the debt.
So that's Sun Legend and Pace.
Yeah, which you launched,
Yes,
exactly.
the
It's the judge's instinct was that in her experience, she was normally used to seeing cases where the relevant judgment had been enforced by judgment of common law or registered under the relevant act. And we would say that it's telling that there aren't any cases beyond this handful of, less than a handful, in fact, fingerful, of one decision of His Honour Judge Peril, QC, sitting as a High Court judge in relation to a demand, and then some ICC judge decisions, one of which related to costs after demand had been withdrawn. Anyway, Lords, the 1933 Act, the proposition, my Lords, that the common law treats a foreign judgment, a la Dicey Rule 45, as having no legal effect, is supported in this jurisdiction, is supported by the treatment of registrable and unregistered foreign judgments, specifically under the 1933 Act. And there is a material distinction, Lords, between the 1933, or the registration scheme, I should say, and the 1920 Act as well, and the common law, which is that under the statutes, following registration, the foreign judgment is treated as if it were an English judgment. There is no separate need, or there is no need for a separate English judgment as there would be at common law. But the result is the same. One is effectively enforcing an English judgment. Lords, your Lordship sees sections 2 and 6 of the 1933 Act at tab 2 of your Lordship's bundle, pages 6 and 12. And at page 6, it's section 22B, or 2.2 rather, which first of all sets out what it is a person with the benefit of a registered judgment may do. So under subsection A, registered judgment shall for the purposes of execution be of the same force and effect. Then as if it were effectively an English judgment, your Lordship sees that at the end of the section. B, proceedings may be taken on a registered judgment, and then provisions for interest and then control. And section 6 provides that no proceedings under the heading foreign judgments which can be registered not to be enforceable otherwise, no proceedings for the recovery of a sum payable under a foreign judgment, being a judgment to which this part of the Act applies, other than proceedings by way of registration of the judgment, shall be entertained by any court in the UK. And my Lords, at tab 8 of your Lordship's authorities bundle, we come to the case of a judgment debtor. And the foreign judgment in that case was a decision of a French court which had been registered under the 1933 Act. And the debtor ran a somewhat hopeful argument, which your Lordships can see at page 69, just below the first punched hole, that proceedings in section 2.2b were limited to proceedings by way of execution, and therefore bankruptcy proceedings, which were not a process of execution, didn't then fall within section 2.2b. And therefore, even if one had the benefit of the registered foreign judgment, you couldn't resort to any bankruptcy process. Now, somewhat oddly, the Deputy Registrar acceded to that argument, but there was then an appeal to the Court of Appeal, and this court allowed the appeal, and in so doing, they necessarily had to construe sections 2 and 6 of the 1933 Act. And, my Lords, first of all, please, at the first page of the report, actually, page 67, your Lordships will see that counsel for the appellant was one Mr. Cyril Salmon, as he then was, and his submission, according to the law reporter, was third line, section 2 deals with the registration of foreign judgments. Its provisions have been complied with. And then sixth line, under section 6, his submission was a creditor who's obtained a judgment against a debtor in a foreign court can only proceed in this country by way of registration. And my Lords, then having examined earlier statutes to see what was allowed after registration, which included bankruptcy proceedings, the Master of the Rolls, at page 72 of the report, turns to the 1933 Act. And in the middle of the page, he explains the effect of registration, which is between the two punched holes. The differences between the two acts are particularly striking. Section 2, subsection 2 provides as follows, and then sets out what the section provides, which I've already mentioned to your Lordships. And then, my Lords, at page 73, 11 lines up from the bottom of the page, the sentence beginning, the language taken by itself, that's section 2.2 and B, in my opinion, quite clearly includes proceedings by way of bankruptcy, proceedings initiated by a bankruptcy notice or otherwise. And then he says that that is strongly confirmed by the second great point of difference between this Act and the earlier Act, to which I'm now about to refer. That is section 6. And his Lordship then quotes section 6 of the Act. And then, my Lords, over the page to page 74, 5 lines down, his Lordship says, in other words, where the judgment is registered under the Act, the only thing, bless you, I emphasise, the only thing that the holder of such a judgment is entitled to do is to register it. And after registering it, he obtains the rights which the Act expressly says shall follow upon registration. And then he addresses the debtor's argument that that if the debtor was right, then that would mean that persons with the benefit of a registered foreign judgment were in a worse position than previously been the case. And then, my Lord, your Lordships will, of course, appreciate that when the Master of the Rolls uses the words "the only thing," implicit in those words is the proposition that the creditor, or the person with the benefit of the judgment but not registered, has no right to do anything, including proceeding by way of bankruptcy proceedings, until registration. And it's then that they obtain the benefits under Section 2.2, one of which, under Section 2.2b, is expressly to initiate bankruptcy proceedings.
Sorry, I wasn't keeping up with you properly. Where are you reading from?
So, my Lord, what I was doing was, first of all, it's 5 lines down. In other words,
yes,
where the judgment's registered on the Act, the only thing the holder of such a judgment is entitled to do is to register it. And after registering it, he gets the Section 2.2 rights. And what I was submitting was it's implicit in the words "the only thing" that there is no right to partake of the matters set out in Section 2.2 unless the foreign judgment is registered. And then, my Lord, at on the same page, 15 lines up.
So just
Yeah.
Sorry, go on. I'm just trying to understand how this fits in. So at this stage, we're dealing with bankruptcy, and you needed a judgment. So, in terms of the point you were just making, you've got a registrable judgment. I've forgotten what point you were making now.
Well, the point is this, my Lord, that section, what his Lordship says is that in that passage 5 lines down from the page, is that once, where a person has the benefit of, actually the confusion is coming from the word that's used. Your Lordships may have picked this up. If your Lordships look at line 5 lines down, his Lordship says, in other words, where the judgment is registered under the Act, the only thing the holder of such a judgment is entitled to do is to register it. That doesn't make sense, because, of course, if it's already registered...
So you say it has to be registrable?
It's registrable. So I think that's a typographical error. Otherwise, it's done... Yes, I think that may have been... So in other words, if one reads it as, where the judgment is registrable under the Act, the only thing the holder of such a judgment is entitled to do is to register it, and he then gets the Section 2.2 rights. A fortiori, if he hasn't registered it, he doesn't get those rights. Those rights include, under Section 2.2b, taking bankruptcy proceedings. And therefore, just looking at it broadly, unless you've registered the foreign judgment, you can't take bankruptcy proceedings. That's otherwise, why would Parliament have stipulated in Section 2.2 what it is you can do once you've registered the judgment? And I'll come on to the point about the fact that, of course, you couldn't petition under the 1914 Act for bankruptcy, obviously based on a foreign judgment. You had to have an English judgment. I'll come to that. My Lords, 15 lines up on page 74, the Master of the Rolls says, it seems to me that Section 6 shows that Parliament was intending by this Act to provide that the only method of enforcing foreign judgments should be by registration. That being so, the holder of a registered judgment can do whatever Section 2 tells him that he can do, which obviously includes issuing a bankruptcy notice. And then he says, my Lord, at the foot of page 74, that being so, and that being the construction which I place upon the relevant language of the Act, and his Lordship then refers to the Bankruptcy Act and makes the point that, well, as it happens, one can only, the type of judgment which one can petition based on has to be an English judgment, not a foreign judgment anyway. And Lord Justices Finlay and Luxmore agree. So this court, my Lords, has construed Section 6 of the 1933 Act and has construed what Section 2 of the Act also means. That means that a holder of a registrable foreign judgment, but not registered, can't petition or take bankruptcy proceedings. They can't do anything that Section 2.2 affords the person with the benefit of a registered judgment. And I, as I said, I accept, as the respondent submits, and as the master of the rolls in that case also submitted on page 75, that the relevant bankruptcy legislation was the 1914 Act. And as I say, that only referred to taking proceedings based on an English judgment.
Sorry, can we just? I have lost the thread. It's probably me. I'm sorry. So if this just shows that I'm lagging behind the field, I apologise. This case concerned a foreign judgment that had been registered.
Correct.
And I thought I understood that the decision was that once registered, you could bring proceedings because Section 2.2b allowed you to do that. And proceedings included the presentation of a bankruptcy petition. Right. So why are we sort of going all the way around the houses on this? That doesn't that you say that's not that's perfectly consistent with your
because
your argument.
Yes,
your fundamental argument, which is that this you have to register a foreign judgment. They weren't dealing with the question about an unregistered foreign judgment.
Accept that. But my point is, if that's what the position is in relation to registered and or if what the position is as regards judgments which are registrable but not registered, that's to say no legal proceedings can be taken on the back of a registrable but unregistered foreign judgment, and that includes bankruptcy proceedings, then the point is it would be very surprising if the common law position were different. It would be very surprising that persons with the benefit of a foreign judgment but which hadn't been enforced with common law would stand in a better position than persons who had the benefit of a registrable but unregistered foreign judgment. That is the point, and also because of the points which are made by my learned friends in their respondents' notice when they say that Section 6 of the 1933 Act doesn't apply to bankruptcy proceedings. They seek to argue, as your lordships will have seen, that this court's decision in rea judgment debtor was wrong, or obiter, or per incuriam, which it wasn't. And they by so arguing, it's there in their skeleton, by so arguing, they seek, therefore, to attack what's been called the anomaly argument. And all our submission is that Section 6 and Section 2 of the 1933 Act, coupled with this court's decision in rea judgment debtor, makes the position crystal clear, irrespective of the fact that obviously the 1986 hadn't been enacted back in 1933. The position is that if one has today a judgment which is subject to the statutory registration scheme and you haven't registered it, you cannot issue a bankruptcy petition or a winding up petition. If you want to do that, you've got to register it. And that's the effect we say.
At the risk of confusing myself, I can't remember whether Mr. Phillips says that the 86 Act operated to vary the position under the 1933 Act.
He does say something to that effect. Your lordships look at the respondent's skeleton argument, Lords, please, at page, page 16. What my learned friend says at paragraph 55
This is paragraph 55.
Yeah.
And I mean, just relating this to the query I raised earlier.
Yeah.
How does that fit with the corporate position? I forget when the relevant corporate winding up provision was introduced, or indeed whether it reflected an earlier corporate winding up provision. So would it be said and I know you don't know the answer to this, Mr. Phillips will think about it, would it be said that equally the corporate winding up provision had impliedly detracted from the 1933 Act, or what?
Well,
It's not
I
for
assume
you.
that would be Mr. Phillips's submission. We'll see what Mr. Phillips has got to say in due course.
This is, I can't remember. It's probably governed latterly by the Companies Act 1948,
I can't.
but I don't remember whether that just reflected earlier provisions.
I can't give you, Your Lordship, that answer off the top of my head now. We'll look at that. So, my lords.
So just before we leave judgment debtor, at page 608,
Yeah.
you place particular emphasis on the only thing the holder of judgment is entitled to do. But do you rely on the following passage? If the argument for the respondent were correct, i.e., once you've registered, you can't recover under Section 2.2,
Yeah.
produce the startling result that it wouldn't be open for the holder of a foreign judgment, registrable under the Act, ever to enforce that judgment in bankruptcy. And for this reason, that he cannot sue it, Section 6 prevents him from doing so.
Yes.
So that is the statement that you rely on, is it? That if you've registered, you only get the rights under 2.2a.
Yes.
And so if it's registered and the respondent were right, you couldn't do it in bankruptcy. And if it's unregistered, you can't do it in bankruptcy.
Yes.
But indeed, whether it's registered or
Yes. Yes.
unregistered, Section 6 would prevent you doing so.
Yes.
So it's not that you're putting your argument solely on the expression "the only thing."
No, I don't put our argument solely on that. No.
No.
No, correct.
Thank you.
Thank you, my lord.
Just before we leave this case, and I'm not sure this takes us any further, if
Yeah.
we go back to 604,
Yes.
and there may be more of this, I'm not sure. Just next to the lower hole punch,
Yeah.
the Master of the Roll says, of course, apart from statute, the only way of enforcing the judgment of a foreign court was by action.
Yes.
Now, that goes back to the debate about what you mean by enforcing. But at any rate, there's an affirmation that
Yes.
if you are enforcing,
Yes,
you have
I
to
mean-
go by action.
That's right. I mean, that is the fundamental common law rule, which the judge thought, when we put it before him, was focusing on the wrong point. But it's with respect to the judge, fundamental. My lords, so my learned friends attack rea debtor in a number of ways. Perhaps I'll let them make those points. But we say all the points made by my friends in paragraphs 47, 49, and 50 are just wrong. And this is where, in relation to the words in Section 6, recovery of a debt, because I mean, my friends are stuck, we say, with what this court has held. And in addition, none of the three conditions in Young and Bristol Aeroplane apply. And my learned friends don't say, they don't even refer to Young and Bristol Aeroplane.
Well, this is open to it.
Those set out the three circumstances when this court can depart from a previous decision. And the three conditions are where there are two decisions which are in conflict, where also the court isn't bound to follow a decision of its own, which, although not expressly overruled by the House of Lords or Supreme Court, just can't stand with it. And the third circumstance is where it's not bound to follow a decision of its own if it's satisfied that the decision was given per incuriam.
I'm so sorry, you've lost me as to where you are in the argument. You're suggesting that we can't depart from in rea judgment debtor.
That's right, my lord. I'm so sorry, my lord. It's my mistake then. My lord, what I was doing was commenting on my learned friends' submissions, including in their respondent's notice, to the effect that rea judgment debtor was wrong per incuriam, or doesn't say what we say it says.
But sorry, but before we get to Young and Bristol Aeroplane, you've got to say that what you're relying on was part of the ratio. Because if it was obiter...
No, it is part of the ratio. It's not obiter at all, what I'm relying on.
But you're relying on the reasoning of Sir Wilfrid Green in relation to what Section 6 would prevent, i.e. bankruptcy proceedings on an unregistered judgment.
That's right.
Simply as part of the argument for the ratio of the decision, which is you can take bankruptcy proceedings on a registered judgment because Section 2.2 allows you to do so. Is that not the ratio of the decision?
That is, but also part of the ratio is that construction of Section 2.2 of the Act, which is your Lordship has absolutely got in one. But as part of that, his Lordship construes Section 6. So the ratio is the construction of the 1933 Act, Sections 2 and 6. Section 6 isn't some...
This illustrates a point that I think cropped up in a case I was sitting on, I think last week or the week before, that the whole concept of what is actually ratio these days seems to have taken on a rather amorphous or fluid nature. I mean, my Lord's point to you, I think, is what was necessary for the determination of the decision was to deal with the argument under Section 2, because that's the argument that was being put, I think. I mean, the fact that the judge went by way of Section 6 to sort of take the statute holistically doesn't make it part of the ratio, does it? What he said about Section 6. He may have supported his decision and looked at Section 6. But the actual decision was a much more straightforward one on the basis of this was a registered judgment. And you could, under Section 2.2b, take proceedings which include bankruptcy proceedings, of bankruptcy, instituting a bankruptcy petition, because that was contemplated within the expression proceedings. That's it.
Yes, but we submit that part of that ratio includes also what the Court of Appeal decided Section 6 meant, because the meaning of Section 6 was bound up with the meaning attributed to Section 2 as well. Of course, it was part of the argumentation in order to get to the decision in Section 2, but we say it's also part of the ratio. It can't be, to say it's divorced, somehow it can be split up from this Court's decision as to what Section 2.2 meant. We respectfully submit giving a too narrow a meaning as to what a ratio is. I'm obviously not intending to teach your lordships to suck eggs, but that's our submission. Section 6, this Court's...
No, the point I'm putting to you is that actually we don't want to have to disappear down, actually not an easy rabbit hole about defining what the ratio of the case is, because actually that isn't entirely straightforward, I think, in the modern era. I think the views that have been taken about what is or isn't ratio. But that's isn't that a bit of a rabbit hole for us?
Well,
well, I think you were saying not, which is why you were taking us to Young and Bristol Aeroplanes.
Well, yes,
we're bound by it.
Well, that's exactly the point. I wanted to respond politely to my Lord Justice Snowden. I was trying to find the appropriate...
Why change the habit of a lifetime, Mr. Samek?
Because your Lordship is sitting up there and I'm standing down here. Yeah, and I read to my Lords the passage. It seems to be the section. I read that passage from Lord 74. And it seems to be that Section 6 shows. I read that, but I was, as Lord Justice Popplewell says, you're bound by it. Simple as that. And he won't do, with respect from the friends, to say that the case means something else. Or that...
I wasn't endorsing the proposition.
No, but I know your Lordship wasn't.
I was summarising your proposition.
Well, I appreciate your Lordship wasn't endorsing it. But that is our
your submission. Yeah.
Yes, it is our submission. Your Lordship has, with respect, summarised it completely accurately. And all I was submitting was it wouldn't be open to this Court to depart from the very clear language, rabbit hole or not, employed in that case, because none of the Young and Bristol Aeroplane conditions apply. And I mentioned Young and Bristol Aeroplane because I thought it right to do so, because my learned friends haven't mentioned Young and Bristol Aeroplane, so I thought someone ought to mention Young and Bristol Aeroplane. That's all. Anyway, my Lord, that's what the position is in relation to the 1933 Act. So, my Lord, this being the position as regards registrable and unregistered foreign judgments, the effect of allowing foreign judgments that haven't first been enforced in an action at common law to found a petition, unlike in the case of unregistered, registrable foreign judgments, would be to place the holders, as I said, of the latter in an unjustifiable better position than the former. And we make the submission we do in our skeleton at paragraph 26. Since Section 6 of the 33 Act prevents a petition based on a sum awarded under an unregistered foreign judgment, it must be the case that debt within Section 2672B is not an open-ended concept, and that it must yield to the prior statutory position as laid down in Section 6 of the Act, 33 Act, and the subsequent position is expressed in CPR 74 as far as pertains to foreign judgments under the registration schemes. So in the context of registrable foreign judgments, debt in Section 2672 can only refer to a debt arising under a registered foreign judgment. Now, my Lord, as Lord Justice Newey mentioned a few moments ago, it's the submission of my learned friends that the 1986 Act changed all that. That's their submission in paragraph 55, which I mentioned. And it is said that because Parliament has legislated comprehensively in the field of insolvency, Parliament has demonstrated an intention that the area shall be dealt with entirely by statutory provision. Lords, that submission is wrong for 6 reasons. First, it is a non sequitur. Comprehensively is not the same as entirely. Secondly,
what's the difference between comprehensively and entirely?
Well, comprehensive may mean that many things are considered and dealt with, but it's not the same as the whole. A comprehensive judgment may leave, not a judgment, a comprehensive proposition or statement may leave some things unsaid. And then that's my, okay, if your lordship's not persuaded by that, well, I'll move on to the next point.
Is your point just that there are some holes in the insolvency legislation?
That is the point I was now going to come on to. Correct, but that's a fundamental point. There are holes. Yes, it doesn't purport to be the alpha and the omega in relation to insolvency, and that's demonstrated by the fact that there is no statutory definition.
Well, Lord Newberger said as much in. Was it Nortel Pensions case, or was it? It's one of those cases where he said, you have to fill. You can't invent stuff if you're in the insolvency field, but the legislation isn't absolutely complete, and there are little bits that you occasionally have to fill in. That's what you're saying.
That is what I'm saying. Right. Yes, that is what I'm saying. Moreover, and therefore, there's no surprise that. The question of what is a debt is a matter which should be decided for the purpose of Section 267, is something which should be left to the common law to decide. The common law and statute work hand in glove in many instances.
Okay, sorry.
Yeah.
You had there were 6 points. The first one was non sequitur.
Yeah.
I'll be on to the second point.
Well, the Lord Justice Snowden's statement was the second point. What I've just mentioned now is the third point.
Can I just get your expression of the second point, I guess, in my notes?
Yes, it's that the Insolvency Act is not a complete code, that it doesn't purport to address every single matter for the purpose of bankruptcy and insolvency. And one of those matters is, of course, what is a debt?
It makes use of concepts that exist outside insolvency.
Yeah. Exactly, and that's entirely natural and normal, and why shouldn't that be the case? And, my lords, then, and indeed, in that regard, in relation to the third point, can I show your lordships...
Have I got the third point? Sorry, the third point was...
The third point which flowed from the second point, which was, if you like, a specific example of the generality, which is that in Section 2672B, Parliament has left it to the common law to identify it. And in that regard, in fact, can I ask your lordships to take up the authorities bundle at tab 42, page 799. tab 42, page 799. And at the top of the page, 1412, Dicey says a judgment creditor seeking to enforce a foreign judgment in England, common law can't do so by direct execution of the judgment, must bring an action on the foreign judgment. There's footnote 33. The judgment creditor may serve a statutory demand in terms of the foreign judgment, just as with any other unpaid debt. But if the validity of the debt is contested, and by the way, contested just means there's a no. I'll come back to that point. The issue will have to be resolved in an ordinary action to establish the enforceability of the judgment, and hence the existence, as a matter of English law, of the debt, which is precisely the point that I've been submitting to my lords, that at common law, what gives rise to the debt is the English money order obtained in an action on the foreign judgment, and not any sum awarded under that foreign judgment. And I've already made those submissions, but that footnote in Dicey expresses the matter rather neatly. And then, my lords...
Sorry, can I just... I'm sorry to hold you up.
No.
I'm slightly puzzled by the idea that you can serve a statutory demand if you haven't had your foreign judgment debt recognised or registered, because statutory demands are also creatures of the 1986 Act and seem, so far as I can see, in section 268, to be framed as capable of being served only where there is a debt which has been owed.
But we don't
so debt means something different, does it?
No.
268.
Well, no, because our primary submission is there's no debt. Our primary submission is there is no debt.
Sorry, it's my fault. I'm not making a separate. I thought that the proposition that was here being put forward in Dicey,
yes,
and that you accepted, but I may be entirely wrong, was that before you have had your foreign judgment debt recognised, although you can't serve a bankruptcy petition, you can serve a statutory demand. Is that your case or not?
Well, I'll answer your lordship's question in this way. A person can serve... There's nothing which says a person can't serve a statutory demand whenever they want. I mean, one could serve a statutory demand with no proper basis for it at all. Statute doesn't deal with that. We say it wouldn't be justified, it would not be justified to serve a statutory demand because there is no debt.
So you say you could get the statutory demand set aside as of right?
Yes, correct, because there is no
Which
debt.
doesn't tally all that comfortably with the Dicey footnote.
Well, it's somewhat oddly expressed, and it may be because of what Lord Collins said in Rubin about the theoretical basis for actions on the judgment. But what the Dicey footnote says, and with respect it's perhaps could be worded better, is that it's only, which is consistent with the common law, that it's only once there is a English money judgment on in an action on the judgment that there is then in English law a debt. That is what is clearly stated, and that's correct.
But sorry, I'm going to have to stop you. I don't understand why you're not just saying that the first sentence of footnote 33 is wrong.
Well, I am saying that.
But I thought a moment ago, in answer to one of the questions you were asked, you said that somebody could serve a statutory demand, albeit that it might be capable of being set aside as of right. I mean, I'm not sure I understand this. The point that was put to you is that the definition of a statutory demand is somebody to whom a debt is owed.
Yeah.
And if there is no debt, I'm not sure how they can serve something which qualifies under section 268 1A as a quote statutory demand. It's just not a statutory demand. I mean, yes, it would be set aside, but it'd be set aside not for any other reason than it's actually not a statutory demand.
No, I respectfully agree. There's my clumsy language. What I was intending to say was, a person who claims they have a debt can, if they want, even though there's no justified basis for it, They could serve a statutory demand. There's no legal, there's no correct...
No, they can serve a demand, but it
Yes.
doesn't qualify as a statutory demand.
No, it doesn't qualify. That, I've expressed myself badly. Lordship's array wouldn't properly qualify as a statutory demand because there is no debt. That is our position. There is no debt, and therefore there couldn't properly be a statutory demand. And that is consistent with the common law. The only thing that gives rise to the debt, would be either, in the case of a registrable foreign judgment, that when it's registered, because then it's clothed with, it's clothed as if it's an English money judgment, or in the case of
because
exactly.
because the first sentence does appear to treat a foreign judgment (brackets unregistered) as just like any other unpaid debt. I mean that's just a reading of it.
That's poor. Yes.
And you'd say no. If that's what it means, it's wrong.
That is wrong. It is wrong. If that first sentence is suggestive, or suggests that the unregistered or unenforced foreign judgment gives rise to a debt, so that a statutory demand could properly be served, then that is wrong. And that is our position.
And the second sentence is when it says if the validity of the debt is contested, etc., that the issue will have to be resolved as in an ordinary action to establish the enforceability of the judgment and hence the existence as a matter of English law of the debt. Is that referring to a fundamental question of can you register the judgment, or is it referring to the question about whether there's any dispute about it? How do you read validity?
Well, first of all, the word "the debt" is a wrong use of language. In that, for starters, in that second sentence, I can only think that what's being intended, or what should be said, is if the validity of the foreign judgment is contested and it is not admitted that it creates a debt in respect of which a demand may be issued or petition may be issued, then, because it's always open, theoretically it's always open to the putative debtor to say, yes, I admit, whether it's right in law or not, I admit that this does constitute a debt for the purposes of section 267 and 268 of the Act. It's always open to someone ill-advised to do that. And we would say that's what actually happened in the case of Sun Legend, where the debtor admitted that there was a debt. And so really the rest of the debate in that case was somewhat sterile.
Well, it may be that there's a distinction, which is here being elided, between a foreign judgment on a claim in debt and a foreign judgment on a claim in damages. In the first case, there is already a debt before the foreign judgment is given. And in those circumstances, I can see how, in principle anyway, one could serve a statutory demand based on the underlying debt, irrespective of the foreign judgment. In the latter case, which is what we're concerned with, where the claim is one for damages, and the debt, if it be a debt, is only created by the foreign judgment, then the position may be different, and it may be that the authors in this footnote had in mind the former case. Is that a possible explanation?
Lord, it would be a possible explanation, but it's certainly, that explanation is, of course, not expressed. But your Lordship is right that in this particular case, it was a damages claim, and it was the Russian judgment from the arbitrage court which crystallized or made a liquidated sum for the first time.
Can I
Created the debt.
It created the debt. There was no debt before then.
And it wasn't so much the judgment itself. It was what we would, in English terms, characterise as the court's order, as opposed to its judgment.
Yes,
It was adjudicating upon a claim in damages.
Yes.
And as a result, making an order which created a debt.
Yes, your Lordship is right.
Can I drop one more thing in, just to confuse the matter, which I came across this morning? I think it's section 34 of the Civil Judgments and Jurisdiction Act 1982, which I think says if you've got a foreign judgment, you cannot sue on the underlying cause of action.
Yes.
And that would apply to debt as well as damages.
Yes.
So you couldn't say, look, I've got a foreign judgment, forget about it, I'll rely on my debt claim,
Yeah.
my contractual debt claim.
Yeah.
I mean, just going back to footnote 33, and then we'll leave it alone perhaps, but I mean, what you certainly, I think, do say is that the very last bit of it is right. Because you say the existence as a matter of English law of something described as a debt is only established when in ordinary proceedings you have registered the judgment.
Yes. Or you've obtained an equivalent, or you've instituted an action on the judgment.
Yeah, because
Yeah.
well, I mean, you look back to the text
Yeah.
to which this is a footnote. It's a footnote to a sentence. It says a judgment creditor seeking to enforce cannot do so by direct execution. It must bring an action on the foreign judgment,
Yes.
and that presumably is the action to establish the enforceability of the judgment. And you say, unless or until you do that,
Yes.
there is no debt in existence as a matter of English law.
That's right. So that last line, or the last line and a half or so of that footnote is correct.
Yeah.
And indeed, if that is correct, then it doesn't. Then, as my Lord Justice Popplewell and the rest of your lordships really pointed out, the prior wording in the footnote doesn't really make sense and is wrong. Lords, then. The next point, I think it's the fourth point, section 267, which I made before, has got to be read subject to the 1933 Act and re-adjudgment debtor. Then it wouldn't be surprising in those circumstances that a sum awarded under an unrecognised foreign judgment is also not such a debt, but we've set out the common law position anyway. Then fifthly, the submission that the 1986 Act swept away the common law rules is misconceived. We say when regard is had to the well-established principles of statutory construction, and we make those points in paragraphs 27 and 28 of our skeleton. But let me just show your lordship some of the authorities. It's authorities bundle tab 37, please.
So your fourth proposition, you said very quickly, was what?
The fourth one was section 267 has got to be read subject to the 33 Act and what this court held in re-adjudgment debtor. So I'm just making the point again as another reason why my learned friend Smith is wrong. And therefore it wouldn't be, and it would be not at all surprising in those circumstances that the person with an unrecognised foreign judgment, or that a sum awarded under an unrecognised common law foreign judgment is not a debt within the meaning of the section. And then as far as the fifth point, Benyon, is concerned, my lords, at tab 37, please, and again we've got the same problem, I actually know you can read, I think. Page 700, well now I think we haven't got the correct, the first page is 755, which is right, but then it doesn't work. So, my lords, it's the first main page, which begins general. It's got a 786 in the bottom left-hand corner. And that's got to be read and applied in the context of the general body of law into which it's assimilated. Ordinary rules and principles of the common law will generally apply to and may impliedly qualify the express statutory provisions. And then the comment, your lordship see the comment that is...
Mysterious first sentence, in fact. I mean, it obviously means an act is not enacted in a vacuum, but it says an is not enacted in a vacuum.
Oh, sorry. Yes, absolutely. Yes. There's a
vacuum in the sentence.
There's a True. Yes. Surprising that got missed in the editorial checking, but anyway, that is right. And then there's reference to what Lord Hope said in Surrey County Council. And then the penultimate paragraph, intellectual justification for drawing on existing law in this way is that there's an expectation on the part of legislators and those involved in preparing legislation the courts will continue to act in accordance with and uphold established legal rules and principles. Reciprocal expectation on the part of the courts and legislators will proceed on that basis. And then, important sentence, and it follows that the legislature is presumed to be aware of the existing law, both common law and statute. And then, next page, middle of the page, just below the first punched hole, in all these ways and many more, a new statute needs to be read and applied in the context of the wider body of law. Fourth line, particular issues arise when it comes to determining whether an act is intended to displace or modify the common law, either generally or in its application in particular cases. Of course, axiomatic that Parliament can, if it chooses, displace any principle or rule of law. Equally axiomatic that unless Parliament does so, the principle or rule, if relevant, continues to operate in relation to an enactment. And then, as Mr. Justice Bile said in Morris, it's a sound rule to construe a statute in conformity with the common law, except where or insofar as the statute is plainly intended to alter the course of the common law. And then, my lords, over the page, section 25.8, implied abrogation. There may be implied abrogation or modification of a common law rule where it's inconsistent with the provisions of an act. Of course, we say there's no inconsistency here at all. Common law is complementary, not inconsistent. Then the comment, principles relating to implied repeal apply equally to the abrogation of common law rules. The basic test is whether a common law rule is so inconsistent with or repugnant to the provisions of the act that the two can't stand together. In the context of the common law, the presumption against implied abrogation is bound up with the presumption against legislative interference with the common law. And actually the examples given, or the example given of the United States and Jennings is a case there was no implied abrogation, there was still rule for the operation of the common law offence. But of course we're not actually even in that territory, because it's not as if one's in a realm of two competing strands. What it is, as I've said, is you've got the common law simply informing what is a debt, when there will be, as a matter of English law, a debt, and that is not inconsistent with or repugnant to the operation of the Insolvency Act or its regime. And then, my lords, at 25.9, also an act may impliedly displace the common law, but by considering whether an act has its effect, the courts will consider the extent to which the legislative purpose would be undermined by the common law continuing to operate alongside of it. There's no undermining here. And then, actually, under the comment, there's the fourth paragraph, the question whether an act displaces the common law ultimately on construction, having regard to all relevant interpretive criteria. One test courts have used is to ask whether the existence of a common law rule or principle in relation to a particular matter would cut across a legislative scheme or undermine its legislative purpose. But it doesn't. And going back to that passage I asked respectfully your lordships to read at the end of the Law Quarterly Review asked of Professor Briggs, paragraph 5 conclusion. Professor Briggs says this common law rule is deeply embedded, and if there's going to be any change, it's got to be clearly on the part of Parliament, or I suppose the Supreme Court, and not by some sort of side wind or by implication. And then 2511, which is at page 808, internal pagination, implied displacement by a comprehensive scheme, which is what my learned friends rely on. Where legislation forms a comprehensive statutory scheme for dealing with the matter, this may be taken as an indication of legislative intention that existing common law rights or remedies should not continue to apply in the same circumstances. So there are 2 points there. First is the point which I respectfully adopt, as it were, which the Lord Justice Snowden mentioned, that the 86 Act is not a complete code. But secondly, this case does not fall within the examples given, because we aren't concerned here with a situation where one's got, as it were, competing schemes or anything like that. But in any event, 2511 doesn't apply. And then, my lord, there's going back to the ITC case, if we may, which is in the supplemental bundle, and it's at page 3. It's at page 36 of the supplemental bundle, this was in the context with Mr. Justice Millett's decision on jurisdiction as to whether the ITC was an unregistered company under Section 665 of the Act. Your Lordship see Section 665 of the Act on page 35. And Mr. Justice, Lord Justice Norse, quoted with, or cited rather, with approval what Mr. Justice Millett said at first instance at letter B on page 36. It's one thing to give effect to plain and unambiguous language in a statute. It's quite another to insist that general words must invariably be given their fullest meaning and apply to every object which falls within their literal scope regardless of the probable intentions of Parliament. So the point here is, the debt in Section 267 and 268 does not, in fact, cover a sum awarded under the foreign judgment. That would be contrary to the common law, the well-established common law position, and it can't have been that Parliament so intended. And then, my Lords, the case at Authorities Bundle tab 9, please, which is National Assistance Board and Wilkinson. And that was a case, a rather curious case, which concerned the construction of the National Assistance Act 1948. And the issue was whether a husband was bound to support under sections 42 and 43 of the Act in circumstances, or the wife, in circumstances where she unreasonably refused to live in a home provided by him, or may even have deserted him or committed adultery, in the words of Lord Goddard. And at the top of page 86, Lord Goddard referred to the common law position. He said there can be no doubt that neither by common law nor by the poor law was a husband ever liable to maintain an adulterous wife, nor a wife who refused to live with him in the matrimonial home which he had provided, at least unless she had good cause for so refusing. Then he refers to the distinction between adultery and desertion, but he said that was the common law rule, and then he holds that Parliament, this is the last 15 lines, 20 lines up from the bottom of the page, it is said, it's about an inch above the second punched hole, it's said that the National Assistance Act 48 has entirely altered the law on this subject, that a husband's liable to an order being made against him to maintain his wife, whether she be guilty of adultery or desertion, provided only she becomes in need of assistance and obtains it from the board. Mr. Ashworth didn't shrink from the position to follow that if a woman left her husband to live in adultery and the man with whom she was living continued to live, fell out of work, said that she had to seek support from the board, her husband would still be liable to maintain her unless and until he ceased to be her husband by decree of divorce. That would indeed be a remarkable result, and it's difficult to believe that Parliament would have had any such intention. It's said that this construction is unavoidable by reason of the section being prefaced by the words for the purposes of this Act. It may be presumed the legislature doesn't intend to make a substantial alteration in the law beyond what it expressly declares. And then reference to what Sir John Romilly, Master of the Rolls, said in Minnett's case. And then 8 lines down, Lord Goddard says, in my opinion, it's perfectly possible to give an intelligent meaning to Section 42 effectively without altering the common law, and so too, my Lords, here. And then, my Lords, we also rely on what was said by the House of Lords in Owens and Bracker, which is at tab 11 of your Lordship's bundle at page 163. And again, I foreshadowed this earlier, and this was the point that Section 9.4 of the 1920 Act was to be interpreted consistent with the established common law rule in Appellant and Oppenheimer, which did not restrict the evidence which was admissible to support a plea that a foreign judgment was obtained by fraud to evidence which was fresh. And at page 163E, Lord Bridge says, even without reference to the Sumner Report, section 9.2d, would have to be construed with reference to the common law as understood in 1920. And so too here, the 1986 Act would have to be understood as the common law was at 1986. And the common law in 1986 was no different from what it was 100 years previously in relation to this particular issue, foreign judgments, and what it is today. And my Lord, so we say those matters provide the answer to the judge's comments in paragraph 35 of his judgment, which is at core bundle A/90, that when he said in section 267 of the Insolvency Act, Parliament has legislated to determine which claims can found the presentation of a bankruptcy petition. And then he went on, it hasn't left this question to the common law. Parliament's answer is that only debts that satisfy the requirements of section 267 can found a bankruptcy petition. Therefore, the question before me is what debt means, not what Rule 45 of the common law that it distills mean. Well, that was wrong with respect for reasons which we've already submitted. So, my Lords, a sum awarded under unrecognised or unregistered foreign judgment isn't, as a matter of English law, a debt. And I suppose I've got to have a fallback position, which is that even if it was, which it isn't, but even if it was, it wouldn't be one which is payable immediately or at some future time, because one would then still have to have the English money judgment on the action on the judgment or registration. But your Lordships have the primary position. And so hence we say that the citation from Fletcher, paragraphs 14 and 15 of our skeleton argument, is in point, it's reflective of the position. Now, my learned friends make a number of points, and in relation to Fletcher. They rely on a case which...
If we're dealing with Fletcher, should we look at the passage?
Yes, Lords, we can, which is at Authorities Bundle, tab 43, page 837. Under the heading, creditors who are ineligible to petition in certain circumstances and otherwise eligible creditors precluded by law from presenting a bankruptcy petition against his debtor, though he may still be able to prove his debt and receive a dividend in a bankruptcy brought about through the petition of some other creditor who is qualified to initiate proceedings. Then Professor Fletcher gives an example, but then about 10 lines up, as a general rule, wherever some obstacle would preclude the creditor from taking direct action at law to enforce his claim against the debtor, he'll be equally precluded from resorting to the bankruptcy court as an alternative means of enforcement. Although he may loosely be termed a creditor, such a claimant in reality isn't yet personally owed any proper legally enforceable debt, which can become the basis of the petition. And that is, we say, in point here. My Lords, the respondent produces the case of McGreevy, which is in your Lordship's supplemental authorities bundle. And that's at page 3. And there are 3, and that was a case, or they produced it as authority for the proposition that even though a debt, that's to say sums which were owing in that case to Benfleet Urban District Council, even though it is a sum, a debt, which can't be enforced at common law because of a decision of this court in Liverpool Corporation Home, nonetheless, it is something which can form the basis of a petition. And my Lord, we say that case has got no relevance to our case for 3 reasons. First, because whether or not the decision is one confined to rates or council tax, what is clear is that there was a debt. There was a liquidated sum as a matter of English law owing to the Urban District Council. And as I said, it was simply that that debt was not recoverable by an action at common law. Secondly, the case was not, so that there was already a debt in that case because of the specific sums owing to the district council, unlike in our case, where the debt is created for the first time by the foreign judgment.
So to be clear, if one traced it through, one would find...
Sorry, not the debt, sorry.
Sorry, if one traced this through, one would find some underlying statutory provision which said that in these circumstances, rates were payable.
Correct. The rates were payable under the relevant statutory provision. There was a liquidated sum as a matter of English law. It's just that this court said in the Liverpool Corporation and Hope case, you can't have an action. In our case, there is no debt. There will only be a debt if and when there is an action, if the Lordship accept our argument, we say it's right, if and when there is an action at common law in which they succeed and there is a consequential English money judgment. And in fact, Maloney Jr. Refers to, there are various rating evaluation acts, but we don't need to go into those.
So rating evaluation
rating
acts.
And I think it's the Rating and Valuation Act of 1925. And I'm told that it even goes back to an original Elizabethan statute. But the short point is that there is a specific statutory provision which creates the debt. That's the short point. The second point, as to why McGreevy isn't material, is the case wasn't concerned also with foreign judgments or the fundamental common law rule of sovereignty underlying Dicey Rule 45. And then the third point, which I've made already, is that as in English law, there is no relevant debt until there's the English money judgment. I've been repeating myself. My lords, then, my learned friends rely on the Bishopsgate case, and they say, well, that's relevant, they say, because it shows that one can petition without relying on an English judgment, and that the bankruptcy court can go behind a judgment, to which we respectfully say, so what? It's not authority in support of the proposition that a sum awarded under an unrecognised or unregistered foreign judgment is a debt within the meaning of section 267 or 268. What's said in Bishopsgate is uncontroversial, but we're not concerned with trade debts. We're concerned with an entirely different beast. And of course, the fact that one may petition without a judgment presupposes that there is a debt, which is the point my lords have we've discussed respectfully in argument. And your lordships already have our submissions now, I don't want to repeat them. The fact that one can go behind a judgment, such as in the cases of Re Fraser and Re Hawkins, which we don't need to turn up, which are tabs 5 and 6 of your lordship's authorities bundle, doesn't mean that there mustn't be a qualifying debt in the first place for the purposes of sections 267 and 268. Lords, then...
Can we just go? Sorry, can we just go back to McGreevy?
Yeah.
In a sense, you'll have a chance to reply on it.
Yeah.
And when, but as I understand McGreevy, it's saying the rates which are which have been assessed,
Yeah.
would not be capable of being the subject of any action by the rating authority. So not, in a sense, quote, enforceable in the ordinary way, but could found a bankruptcy petition. So that is an example of debt being given a meaning which is wider than something which is capable of enforcement by action.
It's an example of there being a debt. There was a liquidated sum.
Yes, but it's a liquidated sum, but it's a liquidated sum which you cannot enforce by action, but you can say that it's a debt for the purposes of presenting a bankruptcy petition?
Yes, I accept that. Yes, in the context of the debt arising under the specific council tax and ratings legislation. So that's why when debts are owed to local authorities and councils, and they are debts, they are liquidated sums, they can go off and petition.
But they can be enforced not by a claim for the money, but one can distrain, for example.
Yes.
So it's not that they're a creature which is incapable of enforcement in any way.
Correct.
Just not by action.
Just not by action for a sum certain.
Correct. But not by action. That's what Liverpool Corporation decided, yeah. Correct. But it doesn't, it's not material for the reasons I've given to our case, where the fundamental question is, when does the debt arise? And your lordships already have my submissions on that.
Well, it's obviously not dealing with a foreign judgment.
It's obviously not, no.
No, I mean, I understand that.
Yeah. So we say it's of no assistance to your lordships. My lords, then learned friends rely on authorities in relation to statutory demands, and they say it's all the same scheme. Well, I think I made my submissions on that already, how there is no debt. I'll just make a few other general points. First of all, of course, none of those cases binds this court. Secondly,
I'm forgetting which cases you have in mind.
Yes, I'm sorry. I have my eye on the time. I'm sorry, my lords. So there are two cases which your lordship.
Are these District Judge Musgrave and Judge Pearl?
And also ICC Judge Barber.
Yes, I see.
Which was Muscalev. So
Yes.
It's His Honour Judge Pearl QC, Pace Europe, which is I don't need to turn it up, but it's tab 22 of the authorities, page 361. District Judge Barber in Muscalev at tab 33, page 646. The former was in relation to a North Carolina, I think it was, judgment, but that was a statutory demand case. There was no argument like of the sort at all. Point wasn't raised in relation to dicey or enforcement of foreign judgments at all before Judge Pearl. So it was, on any view, per incuriam, we respectfully submit. And then District Judge Barber's case, Muscalev, was where the statutory demand was withdrawn. And then there was an argument on costs, and there was simply a reference to the Sun Legend case, ICC Judge Barber, the Sun Legend case. And in any event, not quite sure what, I mean, my learned friends rely on those cases. They say then would have been open in paragraph 30 of their skeleton argument. The creditor, they say, would have been free to present a bankruptcy petition. Or we say no, for reasons which we've already made to your lordships. And, my lords, then, my lords, yes, I would say, I don't know what I need to say. Then they make a point in paragraph 27, 28 of their skeleton argument. They refer to what Professor Briggs says. First of all, they refer to the dicey quote, footnote 33, which we looked at a few moments ago. They also refer to what Professor Briggs said in the Law Quarterly Review article at page 768, tab 38. And page 768, there is footnote 12. Though they can use it, which is a reference to the foreign judgment, for the purpose of the statutory demand leading to a bankruptcy application, pausing there, that's wrong with respect, we say. If the liability is contested by the defendant, the entitlement of the judgment creditor to enforce the judgment will need to be established in English proceedings. What's then enforced is the English decision to admit the claim to prove in the bankruptcy. It's similar, but not quite the same. But I've already made my submissions on that, so I repeat those submissions mutatis mutandis. But to the extent that it's material, it's perhaps relevant that the verb that's used, your Lordship may think this is a good point or not, I don't know, but let me try it. That the verb that's used is contested or contest. He doesn't, Dicey and Professor Briggs do not say, as my learned friends say in paragraph 28, that if the debt is disputed on bona fide substantial grounds. They just say contested. And my Lord, we would say that contested simply means a denial. It's a no. It's a bit like in those cases of arbitration where a sum is claimed, which under a contract where there's an arbitration provision, and the person from whom the money is claimed simply says, no, I'm not paying. And your Lordships know Halki shipping. Halki shipping is clear authority for the proposition that a mere denial, the mere dispute, the mere non-payment is sufficient for there to give rise to a dispute falling within the terms of a relevant arbitration clause, so that the issue has to go off to arbitration. One doesn't need, first of all, to see whether the dispute is based on grounds which, say, would survive a summary judgment application. So we would say it's simply being used in the same sense.
You have to distinguish between the question, is there a debt envisaged by the statute, i.e. within the meaning of the statute, and the practice or process which might be used to determine that question. Mm-hmm. Because the mere fact that you cannot, as a matter of practice of the company's court or the bankruptcy court, attempt to petition on the basis of a debt which is subject to a genuine dispute is just a matter of practice or procedure. Yes. It doesn't actually mean that it isn't a debt.
No, I accept that. Yeah. I accept that. But Lordship is right. I was simply addressing the submission made in paragraph 28. That was all. Maybe inelegantly, but that was only the purpose of the point.
You didn't. I know you're going down this paragraph 27. You didn't say anything about Muir-Hunter. I mean, you said something about Dicey and you said something about Professor Briggs. I mean, I think I know what you say about Muir-Hunter. In the sense, I suspect you don't agree with it, but
what I had. Sorry, did your Lordship mean Muir-Hunter?
Yeah.
Yeah. No, I don't agree with it. I mean, I think I mentioned that there's no authority that's cited to support that proposition. That was the bit which my learned friend showed the district judge, in this case at first instance.
But when you say there's no authority cited, I mean, looking at Muir-Hunter, it now cites this case. But before this case, as I understand it, it cited District Judge Musgrave.
Yes.
So authority was cited.
Well, I'm sorry. Authority that doesn't bind this court, and certainly not authority at High Court level. Your Lordship is absolutely right. I misspoke. But in that case, as your Lordship knows, the debtor admitted, the putative debtor, admitted that there was a debt. And in any event, for reasons which we set out in our skeleton, which I won't repeat, it was wrong. The rest of the...
Do you happen to know when... Sorry, how long has that sentence appeared in Muir-Hunter?
Gosh, I don't know the answer to that.
I mean,
maybe we'll sort that.
If it would just be useful to know when it first appeared and under whose authorship.
Yes.
I can't remember. Is Muir-Hunter entirely loose leaf now?
Yep.
I mean, you could obviously go back to the last hard copy, but it may be that Mr. Phillips can see the process along the way. I don't know.
Yeah, we will.
I mean, it's interesting. I mean, the only reason I ask is that, in a sense, if it's been there for a very, very, very long time, I mean, people don't put stuff in without some sort of basis for it, but it would be interesting to know when somebody had that thought and put it in.
Yes, we'll endeavour who's between us to find out. But people can, of course, put things in because that's what they think the position is or should be, when in fact,
Of course, I mean that's what the joys of authorship are, and then they get exposed when you're in court. But
Right.
it would just be interesting to know how long that has been there, because Muir Hunt's been around as a work for a very long time.
Of course, yes.
Anyway, maybe it sounds like somebody else is going to do your homework for you on that.
And then, my lords, then dicey rule 51. My lord, I think I've got just another 10 minutes or so. Do your lordships want me to plough on for 10?
I think we'll break now. So how are we doing in terms of time?
Well, I think we're doing pretty well. I think
This is a really law-heavy bit, isn't it?
Yes, this is the law-heavy bit. Ground 2, there's a bit of law, but I think I can take that pretty swiftly. I think, and then I'll finish by the end of the day.
I think we'll hold you to that, Mr. Summit.
That's what I said I'd do.
Yeah. Well, we rise now and start again at 2 o'clock.
All right,